The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning. Welcome to the Kansas Supreme Court in this version of our docket this morning, as it's being broadcast through our Supreme Court Live channel. We welcome counsel this morning, as well as those who are watching. I would also like to take a minute to welcome Judge Jan Satterfield, who is sitting with the court this morning on this case in the position vacated by the recently retired Justice Carol Beyer. Judge Satterfield is a district court judge in the 13th Judicial District. She primarily hears cases in Butler County and El Dorado, but she may hear cases from other counties in the 13th, which includes Elk and Greenwood counties. Judge Satterfield has served as a district court judge since January of 2011. We are very appreciative that she has taken time from her busy docket to help us out this morning. Like the rest of us, she has read the briefs and is prepared for arguments. She will participate in the case conference and through the decision of the case. Judge Satterfield, we are very honored to have you join us today.
Thank you, and good morning to everyone. It is certainly my honor and pleasure to be here today. Thank you.
Welcome. With that, I will now ask Mr. Doug Shima, the clerk of the Kansas Appellate Courts, to please call the 9 a.m. docket. Mr. Shima?
Thank you, Your Honor. May it please the court. The 9 a.m. docket for Tuesday, October 27th, 2020 consists of one case, appeal number 120946, State of Kansas versus Robert Willard Colson, Ottawa County, briefs both sides. The appellant has reserved 3 minutes rebuttal time. Your Honor, we are ready to proceed.
Thank you, Mr. Shima. Counsel, would you please state your appearances?
May it please the court, the appellant Robert Colson appears through Casper Shire, Kansas Appellate Defender Office, present and ready for argument.
May it please the court, the state appears by Assistant Solicitor General Natalie Chalmers.
Thank you, counsel. Mr. Shire, you may begin your argument.
Thank you, Your Honor, and may it please the court. This is a direct appeal from Mr. Colson's jury trial conviction for felony murder, as well as several additional felonies. The evidence in this case is that Matthew Sheshke was found dead in his home on K-18 highway near Tescott on August 12th, 2017. Mr. Sheshke was last seen alive on the evening of August 11th. Evidence suggested that after a forced entry, Mr. Sheshke was shot with his own handgun. An F-150 pickup truck was missing from the scene. On the early afternoon of August 10th, about 30 hours before Mr. Sheshke was last seen alive, cell phone tower data placed Mr. Colson near K-18 highway, several miles from Mr. Sheshke's home. He was walking from Junction City, where his Greyhound bus had stranded him, to the Greyhound ticketing office in Salina, trying to make the larger cross-country trip from Maine to California by bus. On the morning of August 12th, Mr. Colson used his credit card to fuel up Mr. Sheshke's F-150 in a small Colorado town a few miles west of the Kansas line, and drove that vehicle the rest of the way to California, leaving it parked in a residential neighborhood in Los Angeles. He was eventually apprehended by law enforcement in California. No DNA or fingerprint evidence from Mr. Sheshke's home linked Mr. Colson to these crimes. On appeal, he has challenged the sufficiency of the state's evidence in several ways. First, he's argued that the state's evidence is insufficient to prove that he was ever in Mr. Sheshke's home at all. He has also argued that the jury's verdicts necessarily require improper inference stacking. But I would like to begin with issue 3 in his brief, which is that the state's theory of this case as a matter of law cannot support a felony murder conviction. Felony murder is a killing committed in the commission of, the attempt to commit, or the flight from an inherently dangerous felony. And here the state's theory of this case is that someone broke into this home, took the handgun, and waited. They did not flee from the scene after that handgun theft. They waited for Mr. Sheshke to return home. When he did, There was a killing, and of course, the thief eventually left the scene. But this does not show flight from a completed handgun theft. In fact, just the opposite. Therefore, the question is the killing within the res gesti of the underlying felony handgun theft? And according to this state's decision in State v. Cunellis, the answer must be no. Cunellis held that a felony theft is complete upon a taking of the property. And once that felony theft offense is complete, any conviction for felony murder must be based on a theory of flight from the completed offense and not based on a theory of having been committed in the commission of the theft offense.
Does it matter that there's a factual distinction in that in Cunellis, they had fully removed the property from the possession of the owner, whereas here, just by the facts, we know that the handgun was still in the proximity of the owner and had not necessarily been removed or taken fully from the potential of that owner re-exerting or even having some control, since we don't know exactly how the shooting occurred.
Well, we know enough about the shooting to say that the shooter certainly had control of the handgun. It appears that Mr. Sheshki was in the bathroom and the shooter was in the bedroom across the hall. One of the things that Cunellis says is that asportation does not matter. So I don't see, looking at the facts of Cunellis, I don't see the fact that the handgun was not removed from the property to be significant. The point is that under the state's theory of the case, the thief took control of the handgun without an intent to return it. In fact, had sufficient control to use that handgun against Mr. Sheshki. That is a taking. And once that taking is complete, any conviction for felony murder has to be based on flight from that completed theft, Your Honor. And I do think the facts of Cunellis are important. Cunellis involved the theft of several motorcycles from a dealership. The thieves, essentially, several of them working together, loaded some motorcycles onto a box truck and drove it off. Police were alerted. About 10 minutes later, they began to give chase. That chase ended in a fatal crash. So it was about 13 minutes from the time the thieves left with the property, took the property, and the killing actually occurred.
Mr. Shire, under your explanation or theory, when was the theft complete? When whoever took the gun exerted control over it, utilized the gun? When was the unauthorized control with the intent to permanently deprive completed?
When the thief took the gun with the intent never to give it back, with the intent to keep it. The state's theory of this case was that the gun was taken and the thief waited in the home for Mr. Sheshki to come home, presumably with the intent to kill him when he got there. That shows an intent to permanently deprive. So once the thief has taken the handgun with the intent to permanently deprive, the theft offense is complete. And the state offered no evidence to show that that taking was concurrent or even close to the killing that happened later. And what Cunellis tells us is just a few minutes is enough. About 15 minutes from the completion of a theft and a killing is enough to separate it from being within the res gesti of the completed handgun theft. Here we have much more than that. We have a period of time from whenever Mr. Sheshki left for work in the morning until he came home around 8:30 that night. We know that the theft occurs sometime in that period. We know that the killing happens sometime after he gets home, but the state offered nothing in terms of showing that those two events were so closely connected as to be the same occurrence.
Counsel, what could be considered a more permanent deprivation than the death of the owner of the gun?
Well, I agree that that certainly shows a permanent deprivation, but my argument would be that he was permanently deprived before that, based on the state's theory of this case. Once the property has been taken without an intent to return it, the theft is complete. So the fact that there's a later killing, which I suppose finalizes, certainly the owner is never going to get the property back at that point. But that is not certainly legally required for theft. You don't need to kill the owner of the property to ensure that they never get it back to be convicted of theft. All you need to do is take it with the intent to permanently deprive.
Counsel, I understood the state's theory to be that your client entered the residence with the intent to commit a theft therein and was perhaps surprised upon the arrival of the victim in this case and hid in the bedroom, the furthest point from the entry of the home. And when the victim went into the bathroom, the handgun was located at the bedside, and he used it upon the decedent, the victim in this case. And the description of ambush had more to do with the victim being surprised, not knowing there was presence of someone, as opposed to, I guess, laying in wait in the residence for the sole purpose of killing the victim, Mr. Shosky.
Well, Your Honor, I have two responses. The first one is that the state, I believe in its closing argument, actually used the words lying in wait to describe their theory of the case. Second, I think it needs to be stressed that Mr. Sheshki was Mr. Colson was only a few miles from this home, about 30 hours before the presumed time of death when Mr. Sheshki gets home. And we just have nothing filling in what happens during those 30 hours. So regardless of what the state may have argued, there's just no evidence showing that the completed theft and the killing were so close in time that they can be treated as the same event, Your Honor.
Counsel, isn't it also consistent with his desire to escape and the fact that Shosky was impeding that? He had to use the gun in order to get rid of Shosky so that he could escape.
Well, if the thief goes into the home and takes the handgun, there's nothing preventing the thief from escaping from the handgun theft at that point in time. The theory here is that the thief instead waits for the homeowner to return, then uses the weapon, which is a killing, and then flees the scene. So essentially what we have is a completed theft, a homicide, and a flight, three discrete events.
When we review for sufficiency of the evidence, why does it matter what the state argued? Shouldn't we actually look at the evidence and what are reasonable inferences that the jury could have drawn from that evidence?
We're looking.
Sorry to interrupt, but your argument strikes me as one that is really dependent on what you claim the state argued. But I'm not sure that that matters.
Well, Your Honor, the important thing here, I think, is that the evidence does not show that the killing was closely related to the theft, and it does not show that it was closely related in time to the, and I see that I'm out of time. I'd like to answer the question, Your Honor.
Yes, continue, please.
just as there was a period of unaccounted time before the killing took place, there's a period of unaccounted time after the killing takes place as well. So the credit card evidence places Mr. Colson in Stratton, Colorado at 6 a.m. the day after the presumed time of the killings, but that's a 4-hour drive. So 9 hours later, he's 4 hours away. There's just no evidence to suggest that the flight and the killing are so closely related in time, let alone the theft, the original underlying theft, are so closely related in time as to be part of the same occurrence. We're dealing with a much broader period of time here, Your Honor.
Let me ask a real quick follow-up. Why doesn't the evidence reasonably support a set of facts as described by Judge Satterfield that the defendant was essentially surprised by the return, took the gun, and committed the killing in order to escape?
Even assuming that set of facts, Your Honor, we still have a completed theft that's followed by a killing, and the time that passes between those two takes the killing outside of the res gestae of the completed theft. I'll also say, Your Honor, that I think the state argued the case the way it did because given the timing involved, that seemed to be the best interpretation of the evidence. That the home was empty all day, that it got broken into, and the thief decided that they were going to wait for the homeowner to get back.
But counsel, now we have the verdict, and it's our duty to view all of this evidence in a light most favorable to the state. So going to Justice Stiegel's question, can't that be justified by suddenly finding the gun, realizing that Shoshki is in the way and shooting him so he can get away?
And Your Honor, what I'll say is that still represents a theft, which is complete, and then it's followed by the killing. We still have two discrete events. That's a theft followed by a homicide, depending on what degree of culpable mental state the jury finds.
Is that only because he took it and didn't drop it?
That's because he took it with the intent to permanently deprive. And once the theft is complete, it's complete, and it can't serve as the basis for a felony murder charge. It has to be flight at that point.
Questions? Ms. Chalmers?
The state has 3 main points in rebuttal. First, the state disagrees with the defendant's reading of Kanellis and the importance in this case. Second, the defendant is grossly misunderstanding the state's case. And third, the state agrees with Justice Stiegel that sufficiency of the evidence does not depend on the arguments made by the prosecutor during closing. As to the first point, Kanellis was an error of law by the prosecutor because the prosecutor was arguing that the ongoing theft was a continuing offense, and the jury instructions didn't clear that up, and so they reduced based on a misstatement of law. But the Kanellis court specifically remanded for the jury to decide whether or not the crimes occurred from flight. So Kanellis does not stand for the fact that the flight couldn't have happened, that there couldn't have been a felony murder based on flight. Kanellis even specifically remanded to let the jury make that decision. As to the state's evidence in this case, the state simply agrees with Judge Satterfield's version of the facts. The state did use the statement lying in wait, but there was nothing that the prosecutor even argued, actually, that said that the theft of the gun itself was completed prior to Matt arriving home. It was the state's theory in that same paragraph that defense refers to that the defendant grabbed the gun while Matt was in the bathroom and then proceeded to fire 5 shots to kill him while he was in the bathroom and simply startled Matt and then fled. And then again, to the extent that the state's argument can be misread as some kind of lying in wait for however many hours while the theft was completed, that misstatement has no bearing on whether or not there was sufficient evidence in the case. Unless there are further questions, the state would stand on its brief and ask the court to affirm the conviction.
What exactly is the state's theory as you stand here, Ms. Chalmers, as to what happened here, or does it even matter? I mean, are we just left with certain sets of facts and then we can just make reasonable inferences based upon the facts and the circumstantial evidence, and that satisfies sufficiency? I mean, do you have a theory of how this happened, or does it matter how it happened?
I'm not entirely sure that it does matter. The concrete things that we know are that Matt was murdered probably around 8:45 or 9 p.m. at night, that the house was broken into, that a great deal of circumstantial evidence puts the defendant in the house, and then during or after Matt's murder, the gun was stolen, the dog was stolen, a bunch of items from the house were stolen, and the defendant was found in possession of all those items.
And
I don't think I'm sorry, Your Honor.
No. And so, yeah, we have these collection of facts, and then that supports perhaps the felony murder. I mean, under a scenario that the state articulates. It also supports a second-degree murder at a minimum. But how are we left to parse what this is? We have a set of facts, and we just fill in the blanks. And if it works, that's sufficient enough, as long as the circumstantial evidence fits.
As long as the circumstantial evidence fits and the evidence is viewed in the light most favorable to the state, and that's sufficient evidence to support a conviction, then yes, we have fulfilled our obligation to prove the defendant guilty beyond a reasonable doubt. Here, the most reasonable, and I do think it's a reasonable inference, that the defendant, for whatever reason, was in Matt's home, or we don't know when he arrived at the home. He grabbed the gun at some point, probably pretty closely to when Matt came home. Matt is in the bathroom, probably getting ready to go to the bathroom based on how the shots are fired, but doesn't even have the chance to go to the bathroom before he's shot 5 times by his own gun.
And I counted 3 probablys in there in your explanation. I mean, it's just, it does leave a lot to kind of a speculation of what happened.
Your Honor, we don't have a camera at the time that occurred. We can't prove exactly what happened, and that's common in most killings if we don't have a witness. But the evidence here supports the verdict.
Is there direct evidence that the defendant, or I'll say the killer, was present in the home prior to the victim arriving home?
I don't know that we have anything conclusively supporting that the defendant was in the house, or the killer was in the house prior to the victim being murdered, but
there were some
would make the most reasonable sense. I'm sorry.
I thought there was some timeline evidence as to both of the individuals.
There was timeline evidence as to both. The last thing we have on the timeline for the defendant is a cell phone call the day before the murder that puts him within several miles of the house. He'd been walking, so however long it took him to walk, wherever he went. And then, so we have him in the general vicinity of the house. Then the victim, we know, didn't come home until about 8:30. It just makes more logical sense that the defendant would already have been in the house, because there was a break-in. There's no indication that there was a confrontation at all. Matt was in his bathroom, again, looking like he was getting ready to go to the bathroom. So it just makes more logical sense. I think it's actually the only reasonable inference that the defendant was already in the house when the victim came home.
Counsel, excuse me, Justice Wilson. Go ahead.
Counsel, what evidence supports an inference of burglary that does not require an inference stacking on the inferences required to support a theft conviction?
Well, for the burglary, the facts that we know are that there was a breaking into the house and the items were stolen. The only question is who did it, and the circumstantial evidence points to the defendant in this case.
What's the evidence of a break-in?
The evidence of the break-in, so the main door to the house was left open because there was going to be gas line check or something like that to the house, but the interior door, there was a door jamb that was broken. And the officers, multiple officers repeatedly testified that it looked like there was a break into the house because there was a lock that was broken.
At the time of the break-in, what evidence do you have of the intent to commit a theft at that time?
Your Honor, we rarely have evidence of intent to commit a theft at the exact time of the break-in. We're allowed to use the evidence that the theft actually occurred to support that intent.
Why isn't that inference stacking though, in inferring that there was a theft and then the additional inference that there was a burglary?
I don't see the stacking there, Your Honor. I mean, you're allowed to use different pieces of evidence to point to different elements. Let's see, I have the quote here on inference stacking, which is, permissible inference stacking is not present when different circumstances are used to support separate inferences or where multiple pieces of circumstantial evidence separately support a single inference. We have the property taken. There was clearly theft. Most of the time, people don't break into the house just for the heck of it. When someone physically breaks into an abandoned house and then property is taken, I think you have beyond a reasonable doubt that there's a burglary there. Again, the only question was who did it. And there are multiple pieces of circumstantial evidence that show the defendant did this crime.
And counsel, haven't our appellate courts found that damage to locks, forced entry, provides circumstantial evidence of theft, of intent to commit a theft upon a burglary?
Yes, Your Honor.
Is that enough without more?
I think yes, Your Honor. We don't even have to prove that there's cases where burglary is upheld and then nothing was even taken. So the fact here, we have a stronger case than that because items were actually taken. The truck was taken, the dog was taken, there was clothing taken, there was dog food taken. There was quite a few items taken from the house to just prove that he went into that house with the intent to take things from it.
Ms. Chalmers, I'm not sure that this is a difference with any distinction, but you mentioned several times that Matt was in the bathroom and that perhaps he had been shot multiple times before he had used the restroom. I just want to make sure my understanding of the fact pattern is correct. My understanding was that the KBI noted that there was urine still in the toilet, such that perhaps he had used the restroom, but certainly didn't have time to flush it.
That could be true, Your Honor. I'm not sure why I made the statement that his pants were zipped. So he'd either just was getting ready to go to the bathroom or had finished using the bathroom. But the way the shots were fired, it was very likely, that he was facing the toilet when he was shot. So he was ambushed while in the bathroom.
Thank you.
Thank you.
And counsel, couldn't the state have charged this case under the felony murder theory just as easily as the underlying felony being the burglary? In fact, the state could have charged, even under State v. Dawes that Justice Biles authored in 2016, with aggravated burglary. Those could have been the underlying, or at least the burglary as charged in this particular case, could have just as easily been the underlying felony for felony murder as the theft of the gun.
Yes, Your Honor, I think we might be facing the same. I mean, we had multiple theories we probably could have charged felony theft with. Felony murder with an underlying theft or burglary or different thefts. But I think we might be hearing the same arguments regardless, because the question is when the intent to commit theft. But I would agree that we could have charged with burglary or aggravated burglary as the underlying felony.
Yeah, Ms. Chalmers, I didn't see the charging document. It specified the theft of the gun as the underlying felony. Is that right?
Yes, Your Honor. If there are no further questions, again, the state would respectfully request that you affirm the convictions in this case.
Any other questions? Thank you, Ms. Chalmers.
Thank you.
Mr. Shire, you reserve 3 minutes for rebuttal. You are still muted, sir.
I knew that was bound to happen sooner or later. Thank you, Your Honor. The first thing I'll say in rebuttal is that the state offered no evidence to show that the theft was closely related in time to either the killing or that the killing was related closely in time to the theft. Any theory that assumes they are is pure speculation. We've got a gap of time of around 12 hours, and the jury is guessing at the order of events at that point.
Does that matter if the jury believed that the killing was done to facilitate the escape?
Well, like the way I see it, Your Honor, if the killing is to facilitate the escape, then the killing is still not in the flight from the felony because the flight has not started yet. So we've still got a completed.
I don't understand that. If I kill someone to facilitate my escape from the scene, how is that not part of flight?
Because the flight has not yet started. The flight begins after the homicide.
So you're slicing the sort of statutory timeline awful thin. So it's not felony murder if I kill someone and then flee, even if the killing was in order to make my flight possible.
But again, I think the problem here, Your Honor, is that the state has presented no evidence that the killing was necessary to make the flight possible.
And I understand that's an alternative argument. I'm trying to dive into your legal claim that none of this evidence even matters. And so I guess I'll just last question follow up. Can you cite to us any case that has held that the killing of someone in order to facilitate flight is not a killing during flight?
I'm not off the top of my head aware of any case that says that, Your Honor.
And counsel, you would agree, wouldn't you, that there certainly is a causal connection between the theft of the gun and the killing of the victim? The homicide, there's a causal connection between the defendant's taking of the gun and the homicide itself.
I agree certainly that the gun was used to kill Mr. Sheshki. I think the important question, though, is whether the act that led to Mr. Sheshki's death was committed within the res gestae of the uncompleted theft offense. And I think the state has failed to meet its burden of showing that it was, Your Honor.
Thank you.
Are there other questions? Mr. Shire, give you a few seconds to wrap up if you'd like. I think we took all of your rebuttal time with questions.
No, I'll conclude by asking this court to, I'll submit issues 1, 2, and 4 on the briefs. And we ask this court to vacate Mr. Colson's convictions for insufficient evidence. Thank you, Your Honor.
Thank you. Thank you to both counsel for your arguments. The court will take this matter under advisement. We are now in recess until 11 a.m. Thank you.
Thank you, Your Honor.